Order. Thank you very much. We're very glad to have Alan Downs and Sarah Alban representing the Legal Services Commission and Ministry of Justice to help us with our inquiry into legal aid. And we've been just in the earlier session this afternoon looking at the comparative figures and trying to draw some experience and lessons from that on the basis of the study which the Ministry of Justice commissioned. I'm going to ask Elizabeth Truss to open some questions to you.
Thank you very much. I wondered if I could start off by asking about the Ministry of Justice's assessment of what are the cost drivers of legal aid and how you're planning to address that through the proposed reforms.
I think the principal cost drivers of legal aid are simply the numbers of cases that come through. So if we look at criminal legal aid, it's about the number of people who are interviewed by the police and then the numbers who go on to charge, and crucially which venue they appear in, whether it's the magistrates' courts or the Crown Court. Obviously in some of the areas around debt, social welfare, housing, that kind of thing, we've seen an impact from the recession and increasing numbers of people eligible for legal aid. And in family, particularly public family law, dealing with children at risk of serious harm, then we've seen a significant increase in the volumes, particularly following the Baby Peter case.
Mm-hmm. Can I ask about the cost per case, though, because that is, on the international comparisons, that does appear to be higher than other countries, and it appears to be higher than other common law countries. What would you say is the driver of that cost per case?
I think we only have limited evidence around what drives the individual cost per case, but I mean, clearly it breaks down to a mixture of lawyers' fees and experts' fees. So an individual case will cost us more, typically in crime, if it takes longer at trial. We've also seen in crime a significant increase in the number of pages of evidence which are served, and that drives through into higher fees.
What's driving that increase in the pages of evidence? The complexity of the case or the complexity of the law?
I don't think we know.
Could I ask the same question of the Legal Services Commission?
I think, well, I completely agree with Sarah in terms of the various costs, and I do think expert fees is a driver, particularly in relation to family law, particularly child protection cases. So I think that is an issue that drives costs. I think something else which can drive costs as well is prosecution. So I don't think you should just think about defence, but also prosecution in looking at how cases, the cost of cases comes about as well. But I do think I do agree with Sarah that I don't think there's any definite evidence really.
Could I ask what work the Ministry of Justice has looked at in terms of reforming the whole system, so making the process through the courts more efficient?
We've looked at a number of things. Currently under Lord Justice Goldring, there's a piece of work going on looking at the Crown Court efficiency. Prior to that, led by a predecessor senior presiding judge, a piece of work was done to significantly increase the efficiency of work going through magistrates' courts. CPS, Home Office and others are under the same sort of spending pressures obviously that the Ministry is, and they're all internally looking at what savings and what efficiencies they can drive. The Family Justice Review is looking at whole system reform and will publish an interim report at the end of March, again looking to drive significant efficiencies through this through the system. We're also planning to publish a paper on civil justice in the spring that should look at further driving efficiencies in the civil justice arena. And then there are a number of proposals around guilty pleas and sentencing that we've published that we hope will drive, again, more efficient behaviour. And finally, in the legal aid proposals themselves, some of the proposals around reconfiguring some of the criminal fees we hope will reduce late guilty pleas and again have an impact on sort of more efficient disposal of business.
Perhaps I could put the next question to the Ms. Downs, the Legal Services Commission. In terms of the process within the Legal Services Commission, how have you looked at refining that and making that more effective?
Well, first of all, we have asked or the Ministry of Justice has asked in the consultation document that people respond with the areas where they themselves, as providers in particular, would like to see efficiencies. So we look forward to doing that. We are working with both the Bar Council and indeed the Law Society at the moment to try to simplify the contracts and indeed particularly the specifications that sit with the contracts. So that's work that we are undertaking at present with both. Finally, on civil representation, which I think we would see as being a cost driver for us, it's the most heavily work-intensive part of our business. We are aiming to bring in a new automated and electronic case management system where we would be able to interact with providers electronically, so you stop all the passing around of documentation. And we would hope to introduce that by October of next year. So that is work in place as well. So those two particular issues.
A number of witnesses have suggested that one of the drivers of costs has actually been other government agencies effectively externalising their costs. Has consideration been given to a polluter-pays principle where that cost would effectively be internalised either within other sectors or within other public service areas?
I mean, we do look at those sort of issues. In 2009-10, some £170 million was recovered on behalf of the Legal Aid Fund from costs and damages awarded against non-legally aided parties. And of course, in criminal cases, on conviction, under the old system, people convicted of crime could be asked to pay towards their cost. And under the new system with means testing, people who can afford to pay towards their defence are asked to do so. In terms of other government departments' policies on legal aid, we do conduct a justice impact test as new policies come up. And over the past few years, about £20 million has been transferred from other government departments to the Ministry of Justice. But I think the other thing that we would need to look at is, at the moment, the Legal Aid Fund has fairly complete cost protection against itself being on the losing side. And I think if we had a polluter pay scheme, then it would be reasonable to expect that when the legally aided party is on the losing side, then costs might be recoverable against the Legal Aid Fund. And if we move to that, it probably would leave us even worse off in net terms than we currently are.
Can I just check something there? When you said £20 million had come from other departments, was that part of the process of the court service acquiring responsibilities for the tribunal system? Or was it actually you somehow knocking on the department's door and saying, look, you're costing us a lot of money, I think you should contribute?
It was that, Mr. Chairman. It was part of the interdepartmental clearing of new policies, where we would have identified that if a particular department introduces a particular policy, there would be knock-on costs to the Legal Services Commission, and money was therefore transferred from those other departments to the Legal Services Commission through the Ministry.
Okay, let's clarify what this process is. You say to the department, this policy will generate a larger number of appeals, legal proceedings than previously.
Yes.
But the one thing you can't get at with that, presumably, is bad decision making.
No, that's right. It doesn't get at bad decision making. It's new policy that would create new criminal cases or a new class of criminal case. I think for bad decision making, what we are trying to do is work very closely with other government departments, for example, the DWP, sharing knowledge from tribunal judges about typical mistakes which are made by first instance decision makers and trying to embed a culture of making decisions right first time.
It's not really holding their feet to the fire, is it? I mean, much as that's nice for DWP to have that advice, it's not really imposing a penalty for bad decision making.
Well, I accept there isn't, it's not a penalty, no, but I think there is just an issue really of what would actually cost government more, because there is a danger that if we set up a sort of bureaucratic chasing round of who's made a bad decision, because you haven't necessarily made a bad decision every time you've made a wrong decision.
But if you get a persistent 90% appeals success rate, for example,
yes.
and we have an example of exactly that in the education, special education area, then there must be some bad decisions or something wrong somewhere. somewhere in the department that's responsible, isn't there?
It seems most likely that must be the case, yes.
And perhaps there ought to be some mechanism for pursuing them.
Yes, could I just want to follow up on teachings. A number of other witnesses have also talked about issues within the court service and inefficiencies such as documents not turning up and so on, prolonging cases. What is being done by the Ministry of Justice to address that? And likewise for the Legal Services Commission, there's been a lot of complaints about inefficiency and over-bureaucracy. I mean, you've talked already about your electronic scheme, but there's always a risk with IT systems that sometimes they can create inefficiencies that weren't there in the first place.
Any offers?
So I'm not aware of problems being reported to us in the past about documents being lost directly by the court service, although I am aware of cases where, in particular in the magistrates' courts, prosecutions can't go ahead because, say, the CPFs haven't served documents in a timely way. But if it's direct losses by HMCS, I'm not personally aware of that, though obviously I'd be very happy to look into anything that you've heard and write to the committee.
Just on inefficiency and over-bureaucracy, a few issues there. And people do write to me about the overhead costs of the Legal Services Commission as well. But the overhead costs of the Legal Service Commission are less than 4% of the take on the fund. So actually, if you look at that as the overheads for running an organisation, I don't actually think 4% is overly excessive. On the other issues around being overly bureaucratic, I have to say I would agree in certain instances with a lot of the checking and rechecking that we undertake. But I think it's worth bearing in mind that we have had our accounts qualified now for 2 years in a row, and a lot of the checking that we are required to do is specifically around the qualification of accounts. So, for example, in relation to, it's just an example I'll give you because I was with my staff in Chester last Friday, where we've been looking at the cost both to us and to providers of the checking that we're now having to do around eligibility and chasing people's bank statements, and that is specifically a requirement about the overpayments that have been made in the past. And we will be looking at that very clearly to see whether the level of money that we are recovering justifies the level of cost both to ourselves and indeed to providers, and then we will have to go back and have a conversation with the National Audit Office if we feel that cost to both ourselves and providers is greater than the recovery of monies to us. So it is an issue with which I would have some sympathy.
One thing that's always struck me, having done legal aid work over the years, is that VAT is charged on the fees. I collect it, and then I pay to the Treasury. Why? Why do we do this? One arm of government collecting money to be paid to another. What's the point? What is the point?
I think that's a question for the Treasury.
You'll ask them that next time we see.
I have to pay VAT to the MOJ.
There is one final point, and I just need to deal with it. I have to question. I'm all in favour of databases and the use of computers, but is there not? Are we not entitled to be a little sceptical when the LSC, now having taken on the role of payment of fees for council, are already showing quite significant delays with the new system, and really there's a great concern out there as to the delays that have been caused as a result of the transfer from the court service to the LSC.
Yeah, and I think and I would accept that absolutely, and I think that delay relates to actually inadequate IT infrastructure in both organisations is the truth of the matter, and the map across, and it is with the AGFS transfer. We've been very clear that we're not prepared to have that transferred from the court service to ourselves until it is a point at which we can effectively administer that process, precisely because of the issues that you raise. So yet again, we would have been in a position, if it had transferred last October, of bringing it across and actually not being able to administer it at all. So better leave it where it is until we have got an adequate and appropriate solution.
Okay.
Can I just on the back of that? Have you got an estimate of the increase in costs that might have been incurred by the extraordinary delays in payment to council that the LSC is now famous for? I mean, it will have an upward cost on fees and on costs.
I don't have that on me, and what I would say, however, is if you look at our payment targets and our payment rates against our targets, we are over 90% within our target levels. But I can go away and have a look at that and get back to you on it, no question.
That's it.
Yeah.
Yes, dealing with the essence of the inquiry, that is the proposed reduction in scope under the Green Paper. Just want to, we've already touched on it somewhat with regard to SEN, but I don't know whether any estimates have been made of the potential cost, either to other parts of the MoJ or to other departments, of removing, for example, immigration cases and other areas from scope. Do you have any figures that we could see or use?
The impact assessment attempted to look at the possible impact on HMCS, recognising on the one hand that there would probably be some increase in litigants in person, which would be likely to make some cases take longer, but on the other hand there's the best of analytical assumptions that we could bring to it also suggested that there would probably be some reduction in the overall number of cases. And we accept, I think, that this kind of prediction of behavioural change is extremely difficult. So I don't think we would try to suggest that there's any arithmetical certainty behind what are simply best estimates. In terms of other government departments, of the legal aid changes itself, we haven't made any analysis of the potential impact on other government departments. There was some analysis of the impact of the Jackson proposals on the NHS Litigation Authority, where we think that the combination of the two proposals together would probably save the NHS Litigation Authority in the region of £50 million a year, where although they will continue to defend cases, they won't be paying the same level of uplift and after the event insurances.
So the figure of £350 million that is suggested as the saving is really a speculative figure.
It's not a speculative figure, I don't think, but what I'm saying is that it is necessarily a best estimate.
But it's an estimate that's not based upon any analysis of impact upon other departments.
No, it's £350 million net saving to the legal aid fund, rather than net of wider government impacts.
So the truth is that we really don't know what impact it will have upon overall government spending on legal issues. Shall I just use that phrase rather than legal services? We just don't know, do we?
I think that's true, we don't.
Now, reference has been made to education law and SEN, and the chairman has already asked a question about that. But I mean, with regard to the removal of legal aid from education, has there been any assessment of the impact? What do you think the impact is going to be when, if and when legal aid is removed from that area entirely?
We estimated that approximately 2,000 cases a year would no longer be helped as a result of this change if it was implemented, at an estimated saving of £1 million. I think it's important to just qualify it's not a complete removal, because the assumption still is that where the issue is one of discrimination, as with other areas of discrimination, those cases will remain in scope to the extent that they currently are.
Would it be the case that within that area you've got some cases which raise quite important legal questions and set precedents for others, but you also have decisions which are being appealed against, in which legal representation might really be considered unnecessary, or at least a bit of a luxury, but actually what the process needs to do is to test the facts, if you like, about that particular case?
I think that's exactly right, and we have recognised that where I think the very difficult cases that you described, where you're talking about an extremely difficult point of law, where maybe people's Article 6 rights are engaged, so a right to a fair trial as you get further through the appeal process, we do recognise that various cases which, although out of scope, will need to still be funded through the exceptional funding mechanism.
Through the
exceptional funding mechanism for looking at individual cases which were otherwise out of scope of legal aid under the new proposals.
How much work has been done with the Department for Education, who are about to undergo a green paper of their own on SEN, to understand potential alternative means of dispute resolution within the SEN framework?
Well, the Department for Education agreed the proposals before we went to consultation.
Is it proposed to link up with their green paper work, because obviously they'll be slightly behind the work of the MoJ on its legal aid proposals, but will there be a formalised or concrete liaison with the DFE during its revision process to understand the implications of their proposals and to work up some impact assessments or costings for the MoJ?
Certainly, and we work closely with the DFE. I mean, I meet my opposite number director, I would think on average weekly, and the teams work very closely together and are working, jointly on some areas such as the Family Justice Review. So we absolutely will continue working very closely together.
That brings me just on to the question of family justice. A lot is made of mediation. Has there been any estimate made of the cost benefits of mediation in family law cases? Because bearing in mind the fact that the majority of cases settle out of court anyway, I mean, I'm not saying there could be an increase, but that's a possibility. Have you done any cost benefit analysis of that?
Yes, I mean, the NAO did a value for money report, which was published back in 2007, and the LSC sort of figures continue to support the sort of broad differences, which suggests that the average cost of a legally aided, non-mediated case was around £1,682, whereas where a case was mediated, the cost was around £752.
Is that a case, forgive me, legally aided, non-mediated, is that a case that went to full fight, full...
No, I mean the majority of those won't have done, as you say, they mostly don't. And the NAO considered that if, say, 14% of cases, a further 14% were diverted away, which is obviously a quite now increasingly small number, they thought that the resulting savings would be some £10 million a year.
Yes, moving just on to the criterion of housing scope and imminent homelessness. Now, the proposal is to reduce the scope of legal aid funding on these cases. What analysis has been made of the impact of reduction in scope in that area?
We have made an analysis, but if you just bear with me, I'm going to have to look the figures up for you. Sorry, would it be easier if I wrote? I can get something to you before you meet again on Wednesday.
I'd be happy to do, I'm sure that would be happy, but the supplementary I just want to ask about that area is that has there been, obviously housing cases, and a lot of us on the committee and elsewhere will have had input from citizens' advice groups and law centres in particular who are very, very concerned about the reduction in scope here, but say that the work will not go away. Has there been any discussion with other departments of government, perhaps the Cabinet Office, for example, as to ways of still meeting what is sometimes a quasi-legal demand? Some of these issues can be resolved by negotiation with the local authority, for example. Has there been any discussion with Cabinet Office as to how we can retain some of these local services in order to stop them from escalating to something far more serious and therefore costing the Legal Services Commission even more?
I mean, there have been discussions in government, and it may be that the Minister is better placed to answer some of that when he appears on Wednesday. But I think that the key issue is, although where central government funds these various different forms of providing help, we can take an holistic look across and make sure that decisions are made jointly about what streams of funding continue. We are left with little more than the ability to sort of exhort and encourage where it's the main funders are local authorities. And ministers have been very clear that they hope that local authorities will not prioritise cutting all of these kinds of areas of non-legal but sometimes very specialist, as you say, help. But it's not something which we can necessarily tell local authorities to do.
Mr. Smith.
The 2009 study by the University of York found, amongst other things, that compared to other countries, to some extent, high legal aid costs were offset by lower costs elsewhere in the system. By spending less on legal aid, are we going to reverse the situation and have effectively more expensive courts?
I think that comes back to, in a sense, the point that I was making around litigants in person, and we do accept that where people convert from representative people to litigants in person, there may be some increased cost as cases may take longer. But we also consider that partly through the provision of alternative methods of dispute resolution and mediation in family, that we hope to reduce overall the number of cases that come to court. So even if the unit cost increases, the overall costs won't.
But mediation is already available, isn't it?
It's already available, but not perhaps widely known about, not perhaps pushed as much as it could be, sold as much as it could be, and we think that the take-up could be much better than it currently is.
But there will be those, and there'll be many in family law, that simply will not be fit for mediation because one or two of the parties will flatly refuse to enter a room with the other party.
That is always that's always the case in a hardcore of cases, and we accept that. The issue is whether or not sufficient cases can be diverted away from otherwise coming to court in order that the increased cost of some cases is offset.
Because litigants in person do take up a huge amount of court time.
They do, and I think we do accept that. Although there is some evidence that where there are two represented parties and two non-represented parties, it is the two non-represented parties whose overall costs are less because they spend, frankly, less time back in court arguing again.
Really? That's interesting. Could I ask you one question about family again? I put it to the Professor earlier on. Is there any evidence of a substantial increase in the instructing of guardians ad litem over the past 5 or 6 years?
I'm not aware of the. I don't know the answer to that question.
Well, I don't mean to trick you.
Yes.
If you are able to send a note to the committee, it
Sure.
might be helpful.
Yes.
Thank you. The Ministry of Justice specified the comparator countries which were to be included in the international study to which I referred. By what criteria were these countries determined?
When we say we specified, I mean we discussed it with the university, and I think it was a jointly reached list. But effectively, we were looking to get countries that had a mix, where possible, of common law background, not just looking to sort of the civil law European countries. And we wanted as much of a mix of cases as we could get. We weren't trying to compile a complete list, obviously, of all the jurisdictions there are. It was inevitably a limited study, but we were just trying to get as much of a mix as we possibly could.
Has the Ministry of Justice reviewed practice in any other jurisdictions to inform their proposals on legal aid?
Yes, we have. We've spoken at some length to quite a few other countries, both thinking about legal aid, but also trying to learn lessons about how court procedures can work in other jurisdictions, particularly in the realm of family law in the context of the Family Justice Review.
Could you specify a bit further on that?
Well, we've been quite interested to look at other jurisdictions where mediation is used more, thinking of some of the American states and also Australia. We've looked at the different way that the family justice system works in Scotland, where they have a quite different setup to the setup that we have down here. And we've talked, obviously, to our counterparts in Scotland and Northern Ireland as part of the overall UK jurisdiction about how do they manage to do things differently, what's different about their systems. We've spoken to people like the Canadian Ministry of Justice and also various, as I say, states in the US about what do they fund, what makes them fund. I think it's true that quite a few other jurisdictions, even after the proposed scope cuts, if eventually ministers concluded that they were going with the full range of scope cuts that are being consulted on that close today, there are still quite a lot of other jurisdictions that simply just don't fund the range of advice that we choose to do. So for many other jurisdictions, they're sort of limiting themselves much more closely to criminal representation and some of the child protection work, although often the child protection systems are very different from our own. And so it's been difficult really to sort of find some other area and look at and think they're providing a much better and cheaper service than us. Mostly when they're spending a lot less, it's because they're buying a lot less.
Thank you.
Mr. Gummer.
Thank you, sir. Just on that note about research, I have to say, I would have thought if this is a feature of government as a newcomer, I'm finding increasingly interesting. If a private enterprise was spending £2.1 billion investment per annum, the depth and richness of data they would expect to base those decisions on would be very much greater. And I wonder whether it's a cultural thing, the Ministry of Justice hasn't gone beyond, I think, the excellent research already provided by Professor Downs, but whether there is, or whether it's just a budgetary thing. I mean, why can there not be a better evidence base for making these decisions rather than what seems to be a largely, if you'll forgive me, so kind of anecdotal exploration of comparative costs?
Are you talking about knowledge about our own system or knowledge about other jurisdictions?
Both.
I mean, I think it maybe is a criticism of governments in general that the amount of data collected in straightforwardly comparative ways is very poor. So we're often left in a position where we need to go back to original court files or at the Commission to their original files to do quite in-depth research into the kind of information that we might perhaps have wished predecessors routinely collected but frankly didn't. And I guess there's the balance for government and for the Legal Services Commission, because there's an awful lot more information that I think we would like to routinely collect, but there's a cost to collecting it, both in terms of data and IT systems, but more fundamentally in the sort of the human cost to solicitors and barristers and then the Commission in having to collate and provide information. So, for example, the Commission has moved over the years to a system of much more fixed and graduated fees. Now that means that however much work up to a certain point a solicitor or barrister does on a particular case, they're only going to get a particular fixed fee. Now, it might be very nice for us to know behind that exactly how much work have they done, when did they do it, where did they do it, what type of work it was. But if we tried to collect all of that and require providers to tell us, I think they'd be very, reasonably saying to us, well, look, none of that's going to make any difference to the fee that you pay me, and it would be expensive for us to collect and report it to you, and unless you're going to frankly pay us more, we can't and won't be able to provide that to you. So I think in those terms you'd end up with, if you then said, well, nevertheless you must tell us, you'd end up with very poor quality data, because I think not unreasonably, firms and individuals would probably just write down a number that they thought the Commission wouldn't query, and on we go.
Sounds like the voice of bitter experience.
Yes.
I mean, I take your point on that. But just on the further issue of the impact studies that you have done, I mean, you probably were aware that the President of the Family Division expressed his surprise at the MoJ's assumptions. And in fact, it seems that no one believes, frankly, what you are saying is going to happen as a result of this. I mean, what is your answer to that?
I think we had perhaps one supporter, didn't we, in Sir Anthony May, but...
Yes, I thought I'm glad you didn't grasp that.
Well, I think when we've spoken to practitioners in other contexts, and when you look at the number of people who are not legally aided but who are not either perhaps in a position to fund without worrying about the price their own litigation, there are not very many people of sort of modest means just above legal aid who spend a lot of time as litigants in person fighting through the court. So I think that provided we can provide appropriate support, much more simplified procedures, and we do accept that we need to look at the procedures that people need to go through around relationship breakdown and making applications for contact and those kind of things to facilitate people using our courts more straightforwardly without expert professional help in every case. But we do think that if we continue to provide better information, to provide mediation services, and to ensure that the procedures are as simple and straightforward to access as possible, that sufficient numbers of people will be enabled to sort out their own relationship breakdown issues without needing to bring everything to court, although we do of course accept that there are a hardcore of cases which will and should appropriately come to court in order to be decided by a judge.
Finally, there's been a lot of comment, and Stephen Cobb was on the radio this morning. The FLBA and the Bar Council and the Law Society have all provided their comments on your proposals, most of them largely negative, and we in this committee have been trying to find positive suggestions from them. I wonder whether you have received many positive suggestions and how useful they've been.
Well, I saw today the FLBA's response to our consultation, and it's 300 pages long. So I'm hoping that in there are indeed some positive suggestions, but I honestly couldn't tell you that I've read it yet.
To what extent have you already looked at and dismissed alternatives? And amongst those, was the idea of a stricter merits test for judicial review an issue that was looked at, or is that something to come on to at another stage?
No, I mean, we have continued to look at that. We're very mindful that it's important to maintain the ability of the individual to challenge the state, and we see judicial review as a very important mechanism by which those sort of serious cases can be brought. And effectively the staff at the Legal Services Commission rely on indications of prospects of success from independent counsel, usually employed by potential litigants. Yeah. And it's quite difficult, I think, for staff at the Legal Services Commission to second guess that kind of thing. But we are certainly open to suggestions about how things like the merits test could be tightened up. And I think it's fair to say that we haven't dismissed any alternative at the moment funding suggestions that may be put to us.
And in the case of judicial review, which is fairly topical because we had one minister answering today for his for the outcome of judicial review, you have the problem that people take judicial review to go to judicial review because they're very upset about a decision and wish to change a decision, but tend to win procedural victories rather than substantive victories. Which means that a consultation then takes place,
yes,
which should have happened in the first place.
Yes.
And is there any way we can address that problem, either by penalising departments which keep getting themselves into this situation, or by simplifying the process by which merely procedural failings are identified and dealt with by the court?
I think that's a very interesting suggestion. It's not one I've had put to me before, but I think you do make a very valid point that at the end result of many judicial reviews which are successful is that the public authority can go away and still do what it was always going to do, but it takes it longer to get there. I think the other thing, though, to bear in mind on judicial review, one of the biggest area I think of burden on the courts around judicial review is in the area of immigration and asylum, and there the large numbers of cases do fail at permission stage,
yes,
but most of the ones which are being legally aided go through, and it tends to be people who are funding it through other mechanisms that overwhelmingly are dropping out of permission stage. So there we see a really significant difference between cases which have been through the Legal Services Commission's merits test and cases which are funded through other mechanisms. Obviously we don't know how, whether it be pro bono or through friends and families or through charities, but the Commission's merits test there is making a significant difference to the quality of cases that are taken through.
Mr. Buckland?
Finally, the prisoners' voting scenario had its genesis as a legally aided case. I've heard what you say about the merits test. Is there not also merit in looking at another conjunctive test, which would be the public interest? A bit like the test that is applied by the Crown Prosecution Service, for example, in its decision to prosecute. Could that not be looked at as another criterion by which judicial review applications are judged fit for legal aid or otherwise?
Well, certainly on the exceptional funding cases that the Commission looks at now, it does use the significant wider public interest test as it's one of the main planks under which it decides whether or not a case should be funded. I suppose we would be wary of usurping the function of the court through employees of, in the end, an NDPB of a government department to stop judicial reviews that might seem inconvenient.
You're not stopping them, though, are you? You're not funding.
No, we're just stopping our funding.
There's a difference, isn't there?
Yes.
There is a difference.
Thank you very much indeed. We'll see you again, Alden, on Wednesday. And Downs, we see you on other occasions. Thank you both very much indeed. Order.